This is You and the Law on AM 650. Now back to the show.
Welcome back to You and the Law. Joe Murphy and Joe Battista from the law firm Murphy Battista LLP in Vancouver in studio with us on AM 650. We're talking about personal injury law and persons with disabilities. And gentlemen, if we can take this final segment of the show, I'd like to talk about two groups of persons with disabilities that I'm sure you represent equally. The very young and the very old. Young children who are injured in serious motor vehicle accidents or other type situations, who suffer traumatic injuries, and older people who perhaps aren't injured but who are disabled because of psychological injury, as in dementia. So those are two extremes of the human pendulum, and yet those would represent clients for Murphy Battista, both. There are special rules for children in personal injury law, are there not, Joe Battista?
Yes, there are. We as lawyers have to satisfy ourselves that our clients are able to give us instructions. By definition, anybody in British Columbia under the age of 19 is considered an infant, and by definition, they do not have the ability to instruct counsel. And
okay.
It's basically on their young age and lack of sophistication. Adults who have a cognitive impairment of some kind, be it a brain injury or some type of progressive disease of the mind, dementia, may not have the ability to instruct counsel because of that impairment. And in both of those cases, there needs to be someone appointed to instruct counsel on their behalf. And that gives rise to our fiduciary duty that we talked about.
Sure, yeah.
That person becomes a fiduciary of the person that they're entrusted with.
Is that where power of attorney comes in then? If a caregiver is entrusted with the power to instruct you on behalf of this injured child?
Yes, Sterling. There's basically three main vehicles to appoint a substitute decision maker. Power of attorney is one. That's the simplest. That's the easiest. Mm-hmm. It's inexpensive. A lawyer should do that for you for $100, $150. It's an easy thing to do.
Okay.
The next level would be a representation agreement, and I'll explain what that is. That's a little bit more expensive, but lawyers can prepare those as well. And then there's what's called a comiteeship under the Patient's Property Act, and that is another level of substitute decision making. The difference between the three is that to give a power of attorney and to give a representation agreement, you need the cognitive ability to understand what you're doing.
Yeah.
So if you have an acute injury such as a bad brain injury, you probably don't have the ability to give a power of attorney or a representation agreement.
Course, yeah.
And you're left to rely on a comiteeship, which is a court order that appoints someone to look after your affairs.
Okay, right.
The other big distinction between the three is that when a committee is appointed, which is the most restrictive one, that person no longer has the legal right to transact business. It all transfers to the committee, the person looking after them.
Oh, okay. Under
a power of attorney, I give you a power of attorney. Our powers are concurrent. We both can still do things. Same with a representation agreement.
But on the third level, you forfeit.
Exactly.
Okay.
There's a fourth thing. It's called a litigation guardian. You can have someone appointed just to instruct someone on a particular lawsuit. And that's probably the most common scenario we see. A parent is litigation guardian for their young child. A spouse is litigation guardian for their husband or wife for that particular lawsuit. There's no power of attorney. There's no representation agreement. There's no committeeship. It may develop into one of those later on. If there's a settlement and the person is still under a legal disability, you may need a committeeship later on. But at least in the initial stage, we often start with just what's called a litigation guardian. It's an easy thing to do. It's quick. And it doesn't presuppose that the person's not going to get better.
Right, right.
And it may turn out
leaves a few doors open.
Exactly.
Right? Okay. Joe Murphy, what are the toughest cases for you to handle? Personally, and I suppose as a firm, but what's a real tough assignment for you?
Well, there's two parts of being tough. One, a tough on liability, where the facts of the accident are so difficult or confusing or mixed up. That creates problems. And then there's the injury, and Brain injuries are the most difficult, but a brain injury to a young child is very, very difficult because I've learned from experience you have to wait till that child's 18, 19, 20 years old
Right.
in order to understand how they function as an adult. You can't determine that with any accuracy when they're 10 or 12 or 15. I acted for a young girl many years ago. She was terribly injured when she was 4 years old in a head-on collision. She went through school. She was a very bright kid. Brain injuries don't change your IQ usually.
Okay.
She was on the honor roll throughout high school, and when she finished high school, we determined by trial and error that she was able to work part-time as a cleaning lady, provided she went to the same houses every week, and nothing changed.
Oh, okay.
So she was very bright, and again, IQ usually isn't changed, but her ability to use it is terribly changed.
Ah, okay.
So if you look at this kid when she was in grade 11, honor roll, nice kid, very, very motivated,
Right.
you would have thought, well, she's going to be pretty,
Sure.
she's going to do pretty well.
Sky's the limit.
A year after she finished high school, it was obvious that she was not going to do well.
Right.
So you have to wait. On the facts of the accident, the complexity, I had a case many years ago. I acted for a local girl who, as a high school graduation, got a bus tour of Europe from her parents.
Nice.
And the bus crashed in a tunnel in Paris, and she was terribly injured. And the parents had bought the tour from a White Rock travel agent, which had bought it from a Toronto travel agent, which had bought it from an English company, which had hired a Dutch bus company,
And so
who hired a New Zealand driver.
Okay.
And the accident happened in Paris.
So it's 6 layers deep already.
So yeah, there's complexity. There's also complexity in accidents where you're trying to figure out what happened.
Sure.
Because if I have a client with a brain injury, it's almost inevitable that their memory of the accident and the events around it is wiped out.
Yeah, that's true. That's you hear that quite a lot.
So,
I have no recollection whatsoever of the incident.
So, but those are the difficult ones. The difficult one in trying to sort out what the injury is and how it impacts them, and the difficult one in trying to sort out what the long-term or what the facts of the accident were, what happened.
So if
Who did what?
if you're listening to this program right now and are finding yourself nodding in agreement to some of the statements that our guests have been making, particularly as it pertains to personal injury law and cases or examples that you may see yourself in, and you're unsure as to where to go, particularly if you're involved in an ongoing situation right now, and maybe, just maybe, this is the time to talk to a lawyer. Well, then our very strong recommendation is that you, and all the contact information is available on the website, murphybattista.com, all the email addresses, and how can we help you? It pops right up, and you can submit your inquiry by email or give Joe Murphy or Joe Battista and their staff a call. Get some advice. And for the first consultation, it's even free. Joe Murphy, Joe Battista, gentlemen, thank you so much for being with us on this edition of You and the Law.
Thank you, Sterling.
See you next time.